Hello everybody, good afternoon. I'm Takis Tridimas. I'm Professor of European Law and the Director of the Center for European Law Studies here. Very warm welcome also on my part, although I appreciate this is now towards the end of your course. It's very nice to have you. I think the attendees of the summer course always add a dimension to the a scholarly community of kings, because I know that you come from diverse backgrounds. I know that many of you practice law in one form or another, or indeed are a part of the court system of various countries. And the idea really is to have an exchange of views. You may be involved in some of the cases or have been involved in similar cases that I will be touching on, and you may well know things better than I or my colleagues do. The idea is to discuss the external relations law of the European Union. I will focus mostly on institutional issues, but I will cover also some issues of substantive law. It is an area which is fast moving. The truth is every area of law nowadays is fast moving. But this year we had two important judgments by the European Court of Justice. One is a case called Rosneft, which pertains to the reviewability of measures in the field of common foreign and security policy, and also we had the opinion of the European Court of Justice on the envisaged agreement between the European Union and Singapore, which is also an important judicial ruling. So I will be focusing on those. I will also be covering TTIP, but the truth is there isn't really all that much happening there. It's an area where not much progress has occurred. And this is partly because of the change of the administration in the United States. So I will be following the PowerPoints, which means I would need to be in the vicinity here. The PowerPoints are very extensive. They're not included in your material, but I will pass them to you. Christine will pass them to you. They're almost too extensive. I think there are about 50 of them. I may not go through all of them. And the idea is to have an exchange of views. So please stop me to ask questions, or stop me to correct me, or stop me to disagree with what I say, or seek clarifications. So what I'm looking at is the external relations of the European Union. The European Union has, as an organization, power to regulate the intra-EU affairs, free trade within the member states, also activities within the member states, within the national territories of the member states, but it also has a powerful presence in the field of external relations. And one could classify the external relations of the European Union as falling perhaps into four main categories. And these appear in your PowerPoint: a common foreign and security policy, common commercial policy, development cooperation with third countries, and relations with international organizations. There is a fifth element, which is defense, but in fact it is comparatively underdeveloped. I will not be looking at defense. From those four areas, I will be focusing on the first two, CFSP, Common Foreign and Security Policy on the one hand, and Common Commercial Policy on the other hand. Development cooperation, this area relates to relations between, on the one hand, the European Union, and on the other hand, countries which are developing countries, which are classified as developing countries, less economically developed than the European Union. And there is an element of assistance in development cooperation, it is not these are not agreements that fall within the traditional field of commercial or trade law. There is an element of help provided to those countries on the part of the European Union with a view to assisting to their development. And some of it is connected with former colonial links that some of the member states have. EU relations with international organizations, well, that would include relations with the United Nations. I'm not going to really touch on this except when I discuss economic sanctions, and relations with the World Trade Organization, and this I will come to as part of discussing the common commercial policy. So let's see, the reason why the PowerPoints are so many is that in many of them I have placed the extracts from treaty provisions, just to make it easier to follow the seminar, since I have not provided any written material. So guiding principles of EU external relations, they are provided for in Article 21, Paragraph 1 of the Treaty on European Union. It's worth having a look at it. The Union's action on the international scene shall be guided by the principles which have inspired its own creation, development and enlargement, and which it seeks to advance in the wider world. The narrative here is quite aspirational, as you can see: democracy, the rule of law, universality and indivisibility of human rights and fundamental freedoms, respect for human dignity, the principles of equality and solidarity, and respect for the principles of the United Nations Charter and international law. So here is an overarching provision. Does it make any difference? The answer to that is yes, it makes a difference. I think the EU does take those principles into account in articulating its external relations policy. And in some respects that gives a bias. The EU finds it easier to conclude international agreements with countries which have as it were, less negotiating power, because this way it can impose human rights conditionality, whereas it cannot necessarily do that with countries which are economically powerful and which may not necessarily share the EU's idea of the rule of law. So the principles of Article 21, Paragraph 1 do have a constraining function on the EU's external relations policy. And second subparagraph of that provision, along the same lines, the Union shall seek to develop relations and build partnerships with third countries and international, regional or global organizations which share the principles referred to in the first subparagraph. And there is also a commitment to multilateralism. The Union shall promote multilateral solutions to common problems through, in particular, the framework of the United Nations. And that sets the scene for the articulation of a series of overarching objectives which still exist at an abstract level. These are the objectives of the Union in pursuing its external relations, safeguard its values, fundamental interests, security, independence and integrity, consolidate support for democracy, preserve peace, foster sustainable economic, social and environmental development, encourage the integration of all countries into the world economy, including through the progressive abolition of restrictions on international trade. So there is if you wish, a liberal outlook, an economically liberal outlook here, and also reference ante paragraph F to the protection of the environment and sustainable management of global natural resources. So where does that leave us? Well, I think that leaves us to what Mark Eyskens said, sometime foreign minister of the Belgian government, when he commented on the EU's external relations, that the power that the EU exercises in various areas is uneven. And he said that Europe is an economic giant, a political dwarf, and a military worm, indicating that in trade matters, the European Union has enormous power. It is a global actor, much less so as a political force, and it is pretty ignorable in terms of its military power. Although if you look at the spending, the combined spending of all member states on defense budgets, you will find that it is actually enormous, and in fact one of the highest in the world. So recently, also taking into account developments in the United States, there have been calls for more efficiency. If there is a lot of duplication, if each country has its own military, its own infrastructure, and so on and so forth, the idea being that the European Union could have here a more important role, thereby saving a lot of money. However, these are for politicians. We are lawyers, and we look at the sources of law, and I think it's interesting to look at the constitutional and institutional architecture of EU external relations. There is a fundamental difference between common foreign and security policy aspects on the one hand, and non-CFSP aspects of external relations on the other hand. I think this is a key distinction, and it is a key distinction because the instrumentalities of the CFSP are different, as I will explain. The two are subject to different processes and different legal principles. Hence, the need to provide a boundary between them, which Article 40 attempts to provide. Article 40 states that implementation of CFSP shall not affect the procedures and the extent of the powers of the institutions laid down in the treaties for the exercise of union competencies, and vice versa. There is another subparagraph which states that implementation of the union policies under non-CFSP powers should not affect the procedures and the distinct nature of CFSP, which in practice means that the European Union may not use CFSP processes to achieve EU objectives and may not use EU processes to achieve CFSP objectives. So you can see here that in some cases at least there will be some dispute as to whether a measure should properly be classified as a foreign policy measure, or as a measure, for example, of international trade relations or a development cooperation. Okay, so let me then start with non-CFSP aspects. The European Union is governed by the principle of attribution of powers. This is a fundamental. So there are three, as you are aware, there are three fundamental principles that pertain to European Union law, and they are the following. Primacy. In case of conflict, EU law takes precedence over national law. Direct effect, which means that European Union law may, under certain circumstances, grant enforceable rights to individuals, rights that individuals may enforce before national courts. And thirdly, the principle of attribution of competencies, which means that the EU only has those powers which are given to it by the treaties. It does not have any self-executing powers. Or to put it differently, the presumption of competence lies by default with the member states. Unless competence has been given to the EU in the treaties, then it belongs to the member states. This is stated in Article 5 of the Treaty on European Union, and there are some general rules governing the division of competence between the EU and the member states in Articles 2 to 6 of the Treaty on the Functioning of the European Union. And these articles, Articles 2 to 6, draw a distinction between exclusive competence, shared competence, concurrent competencies, and ancillary competencies. I don't need to go into this in any detail. I think we'll come to look at it as we examine aspects of EU external relations law. I should say this, that by default, when the EU has competence, this is shared competence. In other words, either the EU or the member states may exercise their powers, which means in turn that once the EU exercises its powers, then by virtue of the principle of primacy, a national law must comply with EU law. Take environmental law. This is a good example. Environmental law is an area of shared competence, which means that member states are perfectly free to regulate emissions of a harmful substance until the EU decides to regulate emissions of that substance. If the EU decides to do so, then it has competence, it can do it, and then the member states obviously must abide by the EU standards. Exclusive competence, on the other hand, means that only the EU and not the member states may act. The member states are precluded from adopting legislation, even in the absence of EU legislation. Now, in the context of external relations, the EU acts by concluding international agreements. This is the main legal form by which EU competence is exercised. But because an international agreement, for example on trade, may cover some aspects which fall within the competence of the EU and other aspects which fall within the competence of the member states, it may be that both the EU and the member states have to conclude that international agreement. These are the so-called mixed agreements. Okay, so a mixed agreement is one where both the EU and the member states act as one of the contracting parties. So you will find that most of the significant, as it were, trade agreements are concluded as mixed agreements. Why are mixed agreements important? They're important because, as I said, both the EU needs to conclude them and the member states independently, which means they need to go through the national ratification process. An example with which you may be familiar from recent news is CETA, the agreement between the EU and Canada. This is a comprehensive free trade agreement. Because it covered aspects which fall within the competence of the member states, it needed to be ratified by the member states. Ratification occurs according to the national constitutional requirements of each member state, and these may provide for ratification by the executive, or ratification by the national parliament, or ratification even by regional parliaments. Belgium is an example. An international agreement can only be concluded by the Kingdom of Belgium if it is first ratified not only by the federal parliament of Belgium but also by regional parliaments. Hence the problems with the ratification of CETA, because the Flemish parliament refused to ratify it some months ago, considering that it was detrimental to local interests. So mixed agreements require ratification both by the EU and the member states. They also give problems in relation to negotiation. If the agreement falls both within the competence of the EU and the competence of the member states, the question arises, who negotiates it? How is the process of negotiation to be managed? And the overarching legal principle here is the duty of loyal cooperation. The member states must act within the collective interest of the EU. There is quite a lot of case law that has developed under that principle. Okay, so the EU has only those powers which are given to it by the treaties. We know that from Article 5. The EU is given power in some areas to conduct external affairs, but in an important case decided in 1971, the ERTA case. ERTA stands for European Road Transport Agreement. The Court of Justice held that the external competence of the European Union need not be express. There can be implied external competence. And the court in that case laid down the so-called doctrine of parallelism, which means that where the treaty gives to the Union power in the internal field, to adopt legislation in the internal field, in other words, to regulate intra-EU affairs, the EU also has competence in that area in the external field. Now that's pretty important because it augmented, it broadened the external competence of the European Union very significantly. It is the ERTA ruling, I think, is as important in some respects as the rulings of the court in Costa and Enel and Internationale Handelsgesellschaft. It is an important constitutional judgment. So what was the background to the case? The EU was negotiating, the European Community as it then was negotiating a European Road Transport Agreement, which regulated, as the name suggests, road transport throughout Europe, not only in relation to members of the European Community, and at that time, of course, there were only 6 members in the European Community. So it needed the cooperation of third countries, European countries that were not member states, and the Council decided that this really was a matter for the member states to negotiate. The Commission took the view that the EU, the European Economic Community, as it then was, also had a say, so it was an interinstitutional dispute. The Commission sued the Council, arguing that the Council's decision that the conclusion of the agreement is a matter for the member states is in breach of the treaty. And the court found for the Commission. So implied external competence is important because it increases the power, the treaty-making power of the EU. All right, so 2 issues about competence. As your first bullet point suggests there is a difference between the existence of competence. Does the EU have competence? And ERTA tells us that the EU has competence when this is stated in the treaty, but also by implication. So that establishes whether the EU has competence. Second question, assuming that the EU has competence, what type is that? Is it exclusive? Is it only the EU that can conclude an international agreement to the exclusion of the member states? Or does it need to be concluded together with the member states in the form of a shared competence and in the form of a mixed agreement? Now, this question is answered, or at least an attempt is made to answer this question by Article 3, Paragraph 2 of the Treaty on the Functioning of the European Union. The Treaty on the Functioning of the European Union is part of the Treaty of Lisbon, which came into force in December 2009. And Article 3, Paragraph 2 seeks to consolidate the previous case law. So the idea is that it doesn't necessarily tell us anything new, but it codifies case law developments. And as you can see there, it states that the Union has exclusive competence for the conclusion of an international agreement in 3 cases: when its conclusion is provided for in a legislative act, or where it is necessary to enable the Union to exercise its internal competence, or insofar as its conclusion may affect common rules or alter their scope. I'll say one word about each of them, and then we come and look at this again when we discuss the Singapore agreement. First one appears to be straightforward. The EU may adopt legislation, a directive, and the directive may provide for the conclusion of an international agreement. For example, there could be a directive on harmonization of banking law, as indeed there is, and that directive may then provide that the EU may conclude international agreements in the field of banking law with third countries for exchange of data, for collaboration, and so on and so forth. So what we have there is a specific legislative mandate given by the EU in the exercise of its internal competence by adopting a directive, which gives to the EU also power to conclude international agreements. And in that case, the external making power of the external treaty making power of the EU is exclusive. Second category highlighted in green is a very specific category and need not detain us. In some cases, the EU can perhaps only act via international agreement. There is no EU internal EU legislation, and the only way of effectively regulating an area, for example, regulating fishing stock, measures for the preservation of marine resources. These know no national boundaries, so the only way of doing this effectively is for the EU to conclude an international agreement, because it requires the collaboration of international organizations or the collaboration of third states. So the only way for the EU to exercise its internal competence is by the conclusion of an international agreement. But this area is contained, it's exceptional, need not detain us. The third area of exclusivity, I think, is the most controversial, and it occurs insofar as the conclusion of an international agreement may affect common rules or alter their scope. So if an international agreement concluded affects existing EU legislation, common rules, or alters the scope, then that would need to would make the competence of the EU exclusive. And that obviously is controversial because it gives to EU law what we call preemption. In other words, the existence of EU law, the existence of common rules, preempts the member states, prohibits the member states from acting in the external sphere. To make it more concrete, what examples could one think? Well, there is a lot of EU social law for the protection of workers. There is the International Labour Organization, ILO, which proposes international conventions. The question may arise, can a member state conclude an ILO convention if the provisions of that convention affect EU directives on worker protection or alter the scope? What does this provision mean? How, in other words, does one define the preemptive effect of EU law? Transport is a good example. A member state may wish, or the European Union may wish to conclude an international agreement on air transport, okay? But there are a lot of directives and regulations regulating transport within the EU. The question is, does the existence of the internal EU measures on transport preclude the member states from concluding international agreements? And why is this sensitive? Well, it is sensitive because obviously it has a constraining force on the power of the member states to conduct external relations. And it is also sensitive because there are various ways of interpreting this, this preemptive effect. What does it mean? That a conclusion of an international agreement may affect common rules or alter their scope. You could have three tests of preemption. Okay, if we are to go a bit more into constitutional theory. One, the most favorable to the member states, is contradiction. If an international agreement directly contradicts what an EU directive says, then obviously the member state may not conclude that international agreement, because by doing so it will affect the EU common rules. There is a direct contradiction between the international treaty and the EU legislation. A broader understanding of preemption is the so-called field preemption. This means that if the EU has legislated in an area, then member states cannot legislate or cannot conclude an international agreement in that area, even if there is no direct contradiction. For example, gender equality. There is EU legislation on gender equality. One may take the view that the existence of this legislation means the whole area is occupied by EU law, and member states lose their ability to conclude international agreements in that field. That field preemption. Third kind of preemption, the most federalist, is so-called obstacle preemption, and this would prohibit the member states from concluding an international agreement where its conclusion might interfere with the objectives of an EU common policy, which effectively means that the whole area becomes a no-go area for the member states. The preemption is not particularly developed in EU law. There are judgments in the field of external relations. It is, if you wish, an import from United States constitutional law, relations between the federal government and the states where there is very developed case law. And the truth is, I don't think there is a uniform test. The courts sometimes follow the obstacle test, sometimes follow the field preemption test, sometimes the direct contradiction test. Okay. That's the constitutional structure, competence, institutional aspects. How are international conventions concluded? This is provided by Article 218 on the Treaty on the Functioning of the European Union, and your PowerPoint outlines the salient aspects of the process. First of all, it is the Council that authorizes the opening of negotiations and provides guidelines to the negotiator. The negotiator is typically the Commission, but it need not be. The Council may negotiate, may authorize someone else to conduct the negotiations. And then the agreement is concluded by the Council acting in principle by qualified majority. In other words, not by unanimity, there is no right to veto, but in principle, save in some cases, the Council acts by qualified majority. We are talking about non-CFSP aspects of external relations, yeah? Not about not aspects covered by common foreign and security policy. The consent of the Parliament is required in most cases as well. So Parliament has a power of veto here. You can see these cases in Article 218, paragraph 6. It states the consent of the European Parliament is required in case of association agreements. This is when the EU creates an association with a third country. The agreement on the accession of the EU to the European Convention of Human Rights. Agreements, but if you look at the fourth item, agreements with important budgetary implications for the Union, most international agreements will have such implications, which means most come within the powers of the Parliament anyway. And if you look at the fifth category, again, agreements covering fields to which either the ordinary legislative procedure applies or the special legislative procedure where consent by the European Parliament is required. So any international agreement in a field where the adoption of internal legislation requires the participation of the Parliament through the ordinary legislative procedure would need to be consented to by the Parliament. So the Parliament does have important powers in the field of external relations. Okay. As I said, the agreement is concluded by the Council with the consent of the Parliament. The Commission cannot conclude international agreements. We know this from a case called France versus Commission, and what happens there is the Commission concludes a memorandum of understanding with the US Trade Commission on the exchange of information and mutual collaboration for the enforcement of antitrust law, to facilitate, in other words, the reciprocal enforcement of competition law in the EU and the United States. And France takes issue with this. It considers that it is not the Commission's business to conclude international agreements. The Commission says, well, this is not really an international agreement. This is a kind of administrative cooperation agreement. It does not involve policy issues, and therefore we can do it because we are the competition watchdog. But the Court of Justice would not have any of it. Said this is an important matter of institutional balance. The Commission cannot, on its own accord, conclude international agreements, whether you classify them as administrative agreements, MOUs, or whatever. This power really belongs to the Council. Brexit aspect, everything has a Brexit aspect. Well, a discussion that has occupied, I think, politicians and lawyers in the United Kingdom is whether the withdrawal agreement, the withdrawal agreement of the United Kingdom can be combined with the future, the agreement that will regulate the future trading relationship between the United Kingdom and the EU. To my mind, this is not possible, and it is not possible for a very simple reason, that the withdrawal agreement is governed by the process of Article 50 of the Treaty on European Union. It requires, in other words, a qualified majority in the Council. It is a special qualified majority of the remaining states, and it requires really 20 out of the 27 member states to agree on the withdrawal terms. But an agreement governing the future relationship between the United Kingdom and the EU would be governed by Article 218, because it will be an agreement between the EU and a non-member state. The process is different. It will need to be decided by the Council, acting probably by qualified majority, but it is most likely that it will need to be concluded as a mixed agreement. It will need to be concluded not only by the EU, but also by the member states, the EU and the member states acting as one contracting party vis-à-vis the United Kingdom. So it does not appear to me to be possible to combine the two. You could combine them in the same document, but you would need to follow the procedure that applies to the aspects of the agreement, to the respective aspects of the agreement. There is a provision for the intervention of the European Court of Justice ex ante. This is in Article 218, paragraph 11, 218, paragraph 11. And this states as follows: a member state, the European Parliament, the Council or the Commission may obtain the opinion of the European Court of Justice as to whether an agreement envisaged is compatible with the treaties. So the idea is that before the EU agrees to be bound by an international treaty, at the stage when the agreement is envisaged, the Court of Justice can be asked whether the proposed agreement is compatible with the treaties. And if the court decides it is not, then the agreement may only enter into force by following the procedure for the revision of the treaties themselves, the procedure for treaty revision. So what is the reason for that? The reason is to foreclose the possibility that the EU concludes an international agreement, and then after the agreement comes into force, the Court of Justice decides that in fact the EU did not have competence to conclude it, because that would expose the EU to to liability under international law vis-à-vis the other party. So Article 218 gives this chance to the member states or the EU institutions to get the green light from the court beforehand. And the court has issued some important rulings in that context. I'm providing a selection of them. Back in 1994, the court was asked if the EU could conclude the World Trade Organization agreements. The court came to the conclusion that those agreements needed to be concluded both by the EU and the member states in the form of mixed agreement. Opinion 2 of 13, the court came to the conclusion that the European Union could not accede to the European Convention of Human Rights under the terms of the draft agreement providing for accession. Opinion on the draft agreement on free trade with Singapore, delivered in May this year, the court came to the conclusion that the free trade agreement with Singapore has to be concluded in the form of a mixed agreement, both by the EU and the member states. This is important. This provides an important precedent for free trade agreements to be concluded by the EU. Well, what happens if nobody bothers to ask the court for an opinion and an international agreement comes into force, and then it turns out that this agreement is incompatible with EU law? What would happen, do you think? Suppose that the EU comes to an international agreement with the United States, and that agreement provides for, I don't know, some kind of reciprocal financial assistance, and there is a clause in the agreement which says only men will be eligible for this assistance. Only boys, and girls are not allowed.
Surely it would be outside the Commission's powers to have done that, so that would be, or Council's powers to make that agreement, so it would be more.
Okay, and why would it be outside the powers of the...
Well, if it's something that's specifically contrary to EU law, then
Okay.
the Council can't bind itself to do something it's not allowed to do.
Okay, so your colleague says, well, surely there is a pyramid of constitutional rules. The prohibition of discrimination on grounds of gender is a fundamental principle of EU law. It is provided for in the Charter. It's provided for in Article 2. Article 2, which lays down the values of the EU, talks about equal treatment between men and women. And the EU cannot, therefore, conclude an international agreement that breaches that. Okay, does everybody agree with that?
Or does it stand until it's struck down?
Yes, I mean that is a procedural issue. It's not. I mean, the first step is to decide if the EU, if that agreement would be compatible with EU law. And I think the answer to that is yes. I don't think it would be compatible with EU law. I think your colleague is absolutely right. The EU cannot conclude an international agreement which runs counter to one of the rules of the treaty itself. Is that correct? The question then is, what would? But you're right. The agreement will not. Well, what would be the legal consequences of the incompatibility of the international agreement with EU law?
I mean, the contrary argument is that it should be binding, because otherwise you lose certainty from the perspective of relations with external states, and it's not terribly fair on external states to conclude an agreement with the EU and then we tell us, sorry, we changed our minds. And then
Correct.
And then the Council presumably has to be ordered by the court to fix it in some way.
Yes, I think you are correct on both points. I think it is correct to say that the EU cannot act outside the confines imposed by the treaties. One of these confines is the prohibition of gender discrimination. So I don't think the EU can agree with a third state to discriminate on grounds of sex. I think you're also right that this principle does not bind the other contracting party. It only binds the EU. So the only solution is a messy one. What the European Court of Justice would do is not annul the international agreement. I don't think it has jurisdiction to do that, not unless the other contracting party has accepted that jurisdiction, which typically it would not. But what the court would do is annul the decision of the Council by which it concludes that international agreement. So there are two acts, if you wish. The international agreement, which exists in the plane of international law, and that continues to apply. And as your colleague says, it's not an excuse towards the other contracting party that this runs counter to the constitutional requirements of one of the contracting parties. But the European Union could not apply that agreement. So the result would be that if the court were to annul the Council decision to conclude the international agreement, then the EU would be exposed to liability under international law. This is precisely why we have Article 218 and this process of ex-ante review, but it may not be activated. There is an example. The example is given in your a transparency, Germany versus Council, and it's an agricultural case. It has to do with the bananas regime, agricultural measure. The EU concluded an international agreement on the importation of bananas. This, the Court of Justice found, discriminated against German producers, so there was discrimination on grounds of nationality, and the court annulled the Council's decision to conclude the international agreement, which in turn exposed the EU to liability under international law, so one would need to follow some kind of diplomatic process to sort it out. And your colleague is absolutely right. The agreement, of course, will continue to be in force, and indeed the EU measure concluding the agreement will continue to be in force until and unless is annulled by the Court of Justice. Okay. Final point, when is an agreement attributable to the EU? Well, the issue of attribution is a fairly recent issue, and it results from the fact that ironically, although since the Treaty of Lisbon there is more integration, there is also more action on the part of the member states through international agreements. Take, for example, the European Stability Mechanism Treaty. This is the treaty on the basis of which a number of member states facing financial difficulties as a result of the Eurozone crisis have been able to receive financial assistance. The ESM is an international treaty. The European Stability Mechanism Organization is set up by an international treaty concluded by the Eurozone member states. And the difficulty there is that we have an international agreement which is concluded by some member states, which uses the EU institutions to administer it, because it's the Commission that administers the financial assistance. It is the European Central Bank which is being involved. It's the Eurogroup which decides on the financial assistance. So we have an international agreement which is concluded by the member states, some of them, but pursues objectives very closely related to EU objectives and uses the EU institutional framework. And questions may arise as to whether decisions taken there are attributable to the EU or they are attributable in fact to the member states. There is growing case law, very difficult case law, The case which I put there is one decided in February, I think, or March this year, and has to do with the statement on migration concluded between the European Council and Turkey. You recall that at the height of the migration crisis, as a way of managing it, the EU came to an agreement with Turkey. This is recorded in a so-called statement concluded by Turkey in the European Council, and in broad outline provides that for every refugee who is, or every migrant rather, who is returned from Greece or other points of entry in the EU to Turkey, an asylum seeker who is in Turkey will be relocated to the EU. So it's a kind of reciprocal exchange. This was challenged by an individual, NM, who as a result of the agreement was ordered to return to Turkey, and the General Court came to the conclusion that in fact this international agreement it was not concluded by the European Council. It was concluded by the member states acting together. So it was really not an EU agreement. It was not an EU act. To my mind, and in my view, whatever it's worth, I think it is the wrong judgment. I think the court uses the wrong criterion. It's very, it makes very interesting reading. The court says, well, how do we decide if an agreement is attributable to the European Council or to the member states acting collectively? The court says, well, we have to look at the language, but we really have to look at what was the subjective intention of the of those who signed the agreement, the member states that signed the agreement. And the court says, well, it's unfortunate. The agreement uses the language that refers to the European Council, which is an EU body. But the court says, well, it doesn't really, that is not conclusive. The intention of the governments of the member states, of the representatives of the member states, was to conclude that agreement not in their capacity as members of the European Council, but to conclude it in their capacity as representatives of the national governments. So it follows that it is not an act attributable to the EU, it is not a treaty concluded by the EU, and therefore we don't need to examine whether it is binding, whether it is non-binding. It is beyond the jurisdiction of the European Court of Justice. I think it is a somewhat unfortunate judgment. I think to decide whether an international agreement is attributable to the EU or the member states, we need to look at competence. Who has power to conclude international agreements in the field of asylum or in the field of migration? It needs to be, in other words, a competence-based rationale, not a rationale grounded on the subjective intentions of those who concluded the agreement. At least that had certainly been the case law, the position of the case law before that judgment. Good. Okay. Just some background information. The EU and foreign trade. I've taken this from the EU website. So if it reads like propaganda, it is because there is an element of it in it. The EU is the largest economy in the world, the largest trading bloc, and ranks first in both inbound and outbound international investment. It is true. What the EU is saying, it is correct. And it comes back to the point that I was making earlier about the uneven character of EU competence, very strong in economics, less so in politics, much less so in terms of military power. The truth is that the EU projects its economic power It is a potent actor in international trade, and this is reflected mostly in standards. Most countries in the world follow EU standards than follow US standards. Standards, that is to say, technical standards for the production of goods. Why it is important to follow them? Because then they are uniform and it's much easier to export and import products. So the legal aspect of this is the common commercial policy, okay, which governs trade relations between the EU and third states. And the competence of the EU in trade is exclusive. That's important. It means the member states cannot act in that field. Only the EU may act, the member states may not act, which consequently means it is important to define what is covered by the EU common commercial policy. And here is the scope of CCP under Article 207, paragraph 1. The common commercial policy shall be based on uniform principles, particularly with regard to changes in tariff rates, the conclusion of tariff and trade agreements relating to trade in goods and services, commercial aspects of intellectual property, foreign direct investment, export policy, and measures to protect trade. This is quite a lot. It covers trade in goods, services, it covers tariffs, it also covers foreign direct investment. Tariffs, of course, and trade in goods and customs has always been an aspect of the CCP, even from an early stage in the development of EU law, and that of course makes sense. Why? Because the EU is a customs union. When a product comes to the EU, it makes sense that it will pay the same customs duty whichever country it is imported to, because then it can circulate freely throughout the European Union. So when an American product comes to the European Union, it pays a customs duty fixed by the European Union, and this means that it doesn't really matter whether it comes through the port of Rotterdam or through the port of Marseille or through the port of Southampton. If its country imposed its own customs duty, then it would not be possible to secure free movement of third country products within the EU. Yeah, because if, say, Rotterdam, the Netherlands imposed a 5% customs duty on US products, but Germany imposed only 2%, then clearly US products will come through Hamburg instead of going through Rotterdam. And then you would need to devise a system whereby they could not travel from Germany to the Netherlands without paying the extra 3% customs duty. So it makes perfect sense to have a common customs tariff. This is a problematic area in the event, rather not in the event, but it will be problematic upon Brexit if the United Kingdom chooses not to be or rather if no agreement is reached on customs, then there will have to be some kind of tariff between the EU and the UK. I had a case once on the common customs tariff that came on the definition of pyjamas. They were pyjamas imported from China, and they came to Germany. But they were very nice pyjamas, very posh. And the German customs said, well, these are not pyjamas, these are luxury, they are leisure wear. They were classified as leisure. Now, when you import pyjamas, the import duty at that time, I think it was about 2%. Leisure wear was a luxury product, so it was about 10%. It was a big difference. So the question was whether these products were pyjamas or leisure wear, which in turn required the court to define what is a pyjama. And there was great disagreement because the question was whether something is a pyjama only if it is worn exclusively in bed, as opposed to being worn primarily in bed. And there was a south-north divide, because North European countries said, of course, you only wear pyjamas in bed. Why on earth would you be wearing pyjamas? But the Italian lawyer said, no, of course, you wear pyjamas, you have your siesta, you have your coffee, you float in and out of the house in the summer. So you wear them in bed, but you wear them elsewhere as well. So anyway, I lost the case. But you can see how even trivial issues can lead to legal problems which are financially important. Just one word about the CCP, or two words. Generally speaking, the EU has a very liberal regime. The importation of products from third states is not subject to quantitative restrictions. So in principle, this is provided for by Regulation 2015-478 on the common rules for imports, and the general rule, the default rule is that there are no quotas on imports from third countries. But however, the EU may restrict importation for certain reasons: public security, public policy, or public health. You will find that there are detailed rules, for example, on so-called dual-use goods, products that can be used for both military applications and non-military applications. There are specific rules for certain countries like North Korea, where there are more restrictions. But in principle, the outlook is a liberal one: no quantitative restrictions on goods. There are, however, some measures which are there to protect EU interests, and these regulations I outlined. There are three of them. The first one is against dumping. Dumping occurs where products from a third country are imported on a mass scale at prices which are very low, and therefore disadvantage the domestic market. There is a regulation against subsidized imports. In other words, products exported from a third country to the EU that have received subsidies from that third country. And there is a so-called trade barrier instrument which enables individuals to complain to the EU that other countries, countries effectively which are members of the World Trade Organization, do not comply with the rules of the World Trade Organization. Okay. Interpretation and direct effect of international agreements. I think it's worth saying a word about this. 2 or 3 points. First point, a point of interpretation established by the court in the Polydor case. The court says there that the fact that an international agreement, a trade agreement between the EU and a third country, uses the same language as the EU treaties does not necessarily mean that it will be interpreted in the same way. So the language may be the same, but one needs to look at the objective of the treaties. The objective of the EU has a strong federalist element, which may color the interpretation. That element will typically be absent from an international trade agreement. So even though international agreements concluded by the EU may use the same language, that does not mean that they will be interpreted in the same way as the EU treaties are interpreted. Second case, Kaffenberg, the court admits for the first time that an international agreement concluded by the EU may produce direct effect. It may be possible, in other words, for an individual to rely on that agreement against a member state or indeed against the EU. However, the last case, Intertanko, suggests that a direct effect will not ordinarily be an aspect of an international agreement. The court in Intertanko found that the International Convention on the Law of the Sea, this is an important convention concluded under the auspices of the United Nations, it does not have direct effect, so it is not possible for an individual to bring an action against a member state or against the EU as a matter of EU law for the latter's failure to comply with the International Convention on the Law of the Sea. And this was taken further really in Portugal and Council. From these cases, I think the most important is Portugal and Council, the second case in your PowerPoint, where the court comes to the conclusion that the WTO agreements do not produce direct effect. So if the European Union violates a WTO obligation, it is not possible for a trader who has suffered as a result of the violation to sue the EU for its failure to comply. Now that's important, obviously, because it increases the discretion of the EU, it diminishes individual rights. So why does the court decide this in Portugal versus Council? It decides it on two grounds. First, the court says there is an issue of reciprocity. If we give direct effect to WTO, there is no guarantee that other contracting parties like the United States or Japan will also give direct effect to the WTO. In other words, there could be a situation where if a US trader suffers because the EU does not comply with the WTO, if WTO was given direct effect in the EU, then that US corporation could claim a right against the European Union. But if the US failed to comply with the World Trade Organization, there is no guarantee that a European exporter who suffered as a result of the US government's failure to comply would get a remedy before an American court. So the court resorts back to the classic principle of reciprocity. This is another ground given by the court, and this is that, in fact, under the dispute resolution system of the World Trade Organization, there is no legal remedy, strictly speaking, in the sense that even if the appellate body of the WTO finds that a contracting party has violated WTO, there is a process of negotiation. What would happen to remedy the violation? And the court says, well, if we were to give a judicial remedy, then that would render the process of negotiation meaningless. It would remove, in other words, any negotiating power that the EU might have to remedy the violation. So, an interesting case, Portugal versus Council. The court, in effect, refuses to constitutionalize the world trading system. This is what the court does. It can give rise to very unfair results. FIAM, the case after Portugal, is an excellent example. And what happens in FIAM? is this. The EU fails to comply with WTO rules. It fails repeatedly, and eventually the appellate body of the WTO, which is the part of the dispute resolution system there, authorizes the United States to impose sanctions on the European Union as a result of as a penalty for the EU's failure to comply. And the anti-WTO rules, sanctions can be imposed in any area, not only in the area where the violation has occurred. So the EU violated agricultural rules, but the United States took countermeasures in the field of electrical equipment. So it imposed 100% duty on the importation of electrical batteries from the EU to the US. So what happens here is you have a company, FIAM, that makes its living out of exporting electrical equipment to the United States and suddenly faces an 100% duty on its exports, which makes, of course, its products uncompetitive. Why would a US purchaser pay twice the price? So FIAM's claim is we are suffering because the EU violated WTO obligations. The claim is, what about us? The EU is trying to support its agricultural industry, and this is why it's violating WTO, and we are suffering collateral damage, which we would not have suffered had the EU complied with its obligations. But the court decides that FIAM has no remedy because there is no direct effect. It does not have a right vis-à-vis the EU that the provisions of the World Trade Organization agreements must be respected. So FIAM illustrates the harsh effects, if you wish, of the Portugal ruling. Maybe you should have a break. I'm aware that this is very intense and the lecturing is one-sided. So let's have a break and then we convene. About 5 minutes, I think, 10 minutes. Let's say. Okay, sure, by all means, yes. Wait. Okay, maybe you can start. So I was saying that the European Court of Justice in Portugal versus Council and then subsequently in FIAM came to the conclusion that in principle the World Trade Organization agreements do not create rights, do not produce direct effect in EU law. So a trader that has suffered loss or has otherwise been injured by the EU's failure to comply with the World Trade Organization commitments cannot have an actionable right before a court of a member state for breach of EU law. And as I said, the rationale for this is twofold. First of all, the reciprocity, and secondly, the need not to prejudice the negotiating position of the Commission in the event that the EU is found to have violated WTO obligations by the appellate body of the World Trade Organization. And indeed, other countries do not appear to give direct effect to WTO agreements. At the bottom of your transparency, you will find a reference to the Medellin case. This is a US Supreme Court judgment where the court decides that international agreements, in this case not a WTO agreement, are in principle not self-executing. I do not have direct effect in US law unless certain conditions which are strict are complied with. Okay, I said earlier that the common commercial policy includes foreign direct investment. This is the case since the Treaty of Lisbon, which means that it is for the EU to negotiate investment agreements with third countries. Exactly what foreign direct investment means is a matter of interpretation and can be open to dispute. I will come back and look at the Singapore opinion later. But one of the issues which I think is worth exploring now is this. A number of EU member states have bilateral investment treaties, BITs, with third countries. These were concluded typically before the member states became member states. So, for example, after the fall of communism and the opening up of the markets in Central and Eastern European countries, many of those countries, indeed all, concluded BITs, bilateral investment treaties, with other countries, especially the United States. It was a means of opening up the markets to a much needed foreign investment. So if investment is now a matter of EU law, what happens to these bilateral investment treaties? Take the following hypothetical. Suppose that there is a bilateral investment treaty between the United States and Hungary, which was concluded, say, in 1990 or 1992, okay, before Hungary became a member state of the European Union. And under the bilateral investment treaty of our hypothetical, a United States corporation, X PLC, contracts to build a power station in Hungary, and in return it is guaranteed two things. First of all, it is guaranteed to have the right to a certain capacity in the Hungarian grid, that it will supply certain capacity of electricity, and that it will do so under a set tariff for a period of 20 years. And this way it will offset its costs for building the power station and will make a profit. This is a perfectly reasonable scenario in a bilateral investment treaty. But then Hungary becomes a member state of the European Union, and the European Union adopts an electricity directive, and the electricity directive requires all member states first to offer non-discriminatory access to the network. In other words, everybody should have access to it. That clearly means that X corporation cannot have the exclusive right to a certain level of capacity. That would run counter to the principle of non-discrimination. Suppose that the EU directive also requires member states to impose an environmental levy to offset the harmful effects of electricity generation for the environment. So Hungary goes to X corporation and say, well, we guaranteed you a tariff for 20 years, but you now have to pay the levy. And it's not us, it's the EU that requires us to impose the levy on all corporations. So you can have, in other words, a situation where the commitments that a member state has under EU law contradict the commitments that it had acquired prior to becoming a member state under an international agreement. So what takes priority? Why does the problem arise? Well, it arises because now, under the Treaty of Lisbon, the foreign direct investments is a matter of exclusive EU competence. So can Hungary rely on its obligations to comply with EU law against X? Would it make a difference, perhaps, if you have not a dispute with the US corporation, but with a subsidiary of the US corporation in the Netherlands? Why does that make a difference? Because here we have a bilateral investment treaty which affects rights and obligations between two EU companies, not Hungary and a US corporation, but Hungary and a Dutch corporation. There is some case law developing on this. It would need to be looked at by reference to Article 351. It's worth having a look. This is a provision which intends to lay down a rule of priorities. It says rights and obligations arising from agreements concluded before the 1st of January 1958, when the EEC Treaty came into force, or for acceding states before the date of their accession, between one or more member states on the one hand and one or more third countries on the other hand, shall not be affected by the provisions of the treaties. So this provision appears to respect international law. Okay, so obligations undertaken by Hungary before it became a member state are not affected by the provisions of the treaties. So they remain in force. Okay, that's perfectly compatible with international law. But Article 351, second paragraph, tells a different story. It says, to the extent that such agreements are not compatible with the treaties, the member states shall take all appropriate steps to eliminate the incompatibilities established. So there is an obligation on the member state. The agreement between the member state and the third country remains in force, but there is an obligation on the member state to take all necessary steps to eliminate the incompatibilities established. What exactly does that mean? Is there an obligation to denounce the bilateral investment treaty, for example? So you can see that this can be a point of contention between the Commission and member states of the EU, especially those that acceded in 2003. It can become, as any legal argument, quite detailed and quite sophisticated. Remember here the obligations. In my hypothetical, Hungary has promised to the corporation, to the American corporation, a set tariff for 20 years. It now has the obligation to impose this environmental levy. If it does not impose the environmental levy, this could be state aid under EU law. The failure to impose the exemption of an undertaking, of a selected undertaking from a public charge, may be a violation of the provisions of the treaty prohibiting state aid. If that is the case, then the Commission can seek to recover it. So you can see how difficulties can arise. And if you follow strict logic, I think it is state aid. Well, if that is state aid, so let's just think this through logically. So suppose Hungary says, well, we are not complying. We are charging you. We are charging we are charging X corporation the environmental levy. Okay. Then the corporation can go to an international arbitration tribunal because bilateral investment treaties provide for investment arbitration. Okay. If the investment tribunal finds that there is well, then you have the following problems. Is the investment tribunal bound by European Union law? Typically, bilateral investment treaties state that the tribunal will apply international law. Is EU law international law? If it is, then it will need to be applied. If you take what the court says about Wangen and Luce and the EU not being international law, if you treat, in other words, if you treat EU law as part of the internal law of Hungary, which would be the orthodox interpretation under EU law, then it means that the International Tribunal cannot take EU law into account, okay, because it is not part of international law. If the International Tribunal, the Arbitration Tribunal finds that Hungary has failed to comply with its obligations under the bilateral investment treaty and imposes compensation on Hungary, then following from what you said earlier, if Hungary pays the compensation, that would also be state aid. Okay? The Commission, in other words, could bring an action against Hungary prohibiting Hungary from complying with the decision of the arbitration tribunal. So it is a mess. And these disputes are by no means purely theoretical. You will find that they have occupied both investment tribunals and they are beginning also to occupy the European Court of Justice. Okay, I am aware of time. Let me say one word about the TTIP, although, as I said, this is because I put it, mostly because I put it in the title, rather than because there are any recent developments. What is the Transatlantic Trade and Investment Partnership? It is, in effect, a trade agreement which is currently being negotiated. Okay, it has not been concluded. It is currently being negotiated between the United States and the European Union. And there have been 15 rounds of negotiations since 2013. The international trade negotiations are very laborious processes. First of all, it's difficult. It's difficult to conduct them, and it is difficult to conduct them because there are all sorts of internal constraints. Okay, the government goes there, and it is normally in a democratic regime anyway. It is under the watchful eyes of at least three parties. First of all, the Parliament. The Parliament wants to know, whatever country takes part in the negotiation, the Parliament wants to know what is going on, how much the government is going to give away. Secondly, the industry. The domestic industry has certain interests that it needs to protect, and it would seek to influence the negotiation. Thirdly, trade unions or labor interests will also have strong interests, at least in some aspects of the negotiation. So you have a government that goes into negotiation. It has its own agenda, but this agenda is constrained by its industry. It is constrained by its trade unions. And these are very influential parties because they may also have an electoral say. You have to give them enough to make sure you don't suffer electoral damage. And if you think that each government goes in the negotiation with those aims, it is not easy to always to find common ground. First, the negotiators have to agree what they're going to talk about. So the first round of negotiations is what will be negotiated. What is it that they're going to discuss and how they're going to discuss it. That in itself takes a long time. And as I said, since 2013, we had several rounds of negotiations, about 15 rounds of negotiations as part of the TTIP. It is one of the largest trade agreements in history. If you take the United States and the European Union together, they account for about 50% of the world's GDP. And about, I think, 1/3, bit less, about 30% of the world's trade. And what they are aiming to do is to liberalize reciprocally access to the market. It covers market access in the fields of tariffs, services, investment, and public procurement. It provides or seeks to provide for the removal of regulatory obstacles, such as car safety requirements. It also covers IP rights, environmental protection, and label protection. So it is a huge undertaking. The idea is that there will be 24 chapters in the negotiations, and each chapter is concluded successively, but the general rule in trade negotiations is that nothing is final until everything is agreed. So although the negotiation happens chapter by chapter, you may well have to reopen a chapter if that is necessary to find a political compromise. So the whole thing does not really augur very well for the possibility of a prompt agreement between the United Kingdom and the European Union post-Brexit. And as I said, it covers market access, it covers regulatory cooperation, it covers intellectual property rights. It also covers, it provides for an investment court. There are, in other words, institutional aspects to it. Member states have a say because it's a mixed agreement, and the European Parliament also has a vested interest in being informed of how the negotiations proceed. So we'll see how things develop there. Let me say a word about the common foreign and security policy. This, as I said, is a different kind of animal, and it is because it is not subject to the traditional processes of EU law. Article 24 of the treaty, the Union's competence in matters of common foreign and security policy shall cover all areas of foreign policy and all questions relating to the security of the Union, including the progressive framing of a common defense policy. CFSP, as I said, is subject to distinct rules and procedures. So what are the distinct institutional arrangements? First of all, it is defined and implemented by the European Council and the Council acting unanimously. There is no qualified majority here. It is placed into effect by the High Representative of the Union for Foreign Affairs and by the Member States, so less involvement for the Commission. And in terms of its instruments, there are no legislative measures. So you don't have direct effect, as you have with normal EU measures. Article 25 provides that the Union shall conduct the common foreign and security policy by defining general guidelines and by adopting decisions defining actions to be undertaken by the Union or positions to be taken by the Union and arrangements for the implementation of those decisions. Okay. The Commission and the Parliament have a very limited role, and the Court of Justice has very limited jurisdiction. Hence comes the judgment in Rosneft decided in March this year. So what is the issue? Let's see what the Court of Justice can do in this area. Okay? So Article 24, the Court of Justice shall not have jurisdiction with respect to these provisions, i.e. CFSP provisions. Article 24 is part of the CFSP, with two exceptions. Article 40 and a review of the legality of certain decisions provided for by Article 275. Article 40, you may recall, is the provision which says that implementation of CFSP should not affect the implementation of EU policies, and vice versa, implementation of EU policies should not affect the implementation of CFSP. So the court plays a role there in determining the boundaries. There is a second exception, as you can see. The court may review the legality of certain decisions as provided for by the second paragraph of Article 275 of the TFEU. So what does Article 275 state? Again, it repeats that the court has no jurisdiction in relation to CFSP measures, but it has jurisdiction to monitor compliance with Article 40, okay, and to rule on proceedings brought in accordance with Article 263, reviewing the legality of decisions providing for restrictive measures against natural or legal persons. So let's just decode this. Part of common foreign and security policy is the imposition of economic sanctions. Economic sanctions have been used very heavily by the European Union, and these are effectively freezing of assets orders. They are decisions which, by which the European Union prevents a person or a corporation from having access to its funds. Why are economic sanctions being used? Well, the background to this is that traditionally economic sanctions have been imposed against countries. If a country has an undesirable regime, then the United Nations or other countries may impose economic sanctions on that country as a whole. The trouble with economic sanctions against states is that they have not proved effective. And a drawback of them is that they harm the whole of the population of that country, even though the population is not responsible for the undesirable policy. It is the regime which often would be a dictatorship, often would be corrupt, but the people that are part of the regime are likely to be wealthy or likely not to be affected by the sanctions as much as the population as a whole. So in the 1990s, under the Clinton administration, this idea of smart sanctions came about. The idea is to impose economic sanctions not against a whole country, but against individuals. They were imposed, for example, against specific individuals associated with the government of Yugoslavia in the 1990s. And they have since become the hard side, if you wish, of EU diplomacy. The EU doesn't have a powerful military, as I was saying earlier, but it does use economic sanctions heavily. They were used after September 11 against persons who were deemed to be associated with terrorism to stop the financing of terrorism. So a whole lot of case law developed on economic sanctions against persons associated with terrorism. Cadi was the leading case there. There is a reference to Cadi in your PowerPoints. Please bear with me and I will trace it. Yes, Cadi, you will find it here at the first point. What happens, this is the first case that tests sanctions against individuals in the EU. Okay, it's probably the most important case pertaining to the relationship between European Union law and international law. And what happens there is this. After September 11, the United Nations Sanctions Committee imposes a freezing of assets on individuals who were suspected of being associated with terrorism and financing Al-Qaeda. And one of those individuals was Mr. Cadi, a very wealthy businessman of Saudi Arabian nationality. These sanctions were adopted by the United Nations, and in the EU were adopted by the EU. So the EU adopted a common foreign and security measure, which was then translated into law by an EU regulation. Okay, what are the legal issues associated with this? It's worth going through because it illustrates several points. First point of difficulty is that these are not criminal sanctions, okay? They are preventive sanctions. But they are highly intrusive. So a person loses access to his or her financial resources. But no criminal trial process has taken place. Okay? In the United Nations, the decisions are taken by the Sanctions Committee on the basis of secret information supplied by the intelligence services of various countries. So it is not clear why someone's name has been included. As I said, they are very intrusive, and that is their purpose. I mean, they undoubtedly, the aim that they pursue is in the public interest. The idea is to restrict terrorism, to prevent terrorist financing. Now, on the way they're implemented is inevitably, it reaches a stage where becomes very, very panicky. It's someone's job in the Treasury to look at the supermarket receipts of a person who is in the list. Okay, and if they are only allowed basic subsistence allowance. So if you buy a yogurt, then that's okay. If you buy a yogurt with jam or a fancy yogurt, that's not okay, because it is beyond what is necessary to feed oneself. So they're very intrusive in the way in people's lives. And Mr. Cadi sought to challenge the imposition of the freezing order on him. The EU said, well, that has nothing to do with us. We are just doing what the UN is telling us to do. the European Court of Justice accepts the challenge on the ground that the European Union must respect fundamental rights. The fact that an EU measure originates from the UN is no excuse not to comply with fundamental rights. So what the court is doing really in CADI, and this is a principle of fundamental constitutional importance, is to perceive the European Union as having an enclosed constitutional space. Any measure of the EU, no matter the reason for its adoption, must comply with EU fundamental rights. So the fact that the EU was giving effect to a UN Security Council resolution did not provide the EU with immunity. Secondly, the court then goes on to review the compatibility of the sanctions with EU fundamental rights and finds that the measure is incompatible with them because the rights of defense have not been respected. Mr. Cadi was not given any reasons why his name was in the list, was not given an opportunity to defend his rights. Now, obviously, in this case, you cannot have an advance right of defense. You cannot call someone and say, we are going to freeze your assets in 2 weeks' time, because that person will just take his assets outside the EU. So you can't really comply with the rights of defense ex ante, as it normally would be the case. But the court says you have to give reasons to the person whose assets have been frozen. The measure is annulled, although the court maintains the effects of the measure in force, because the court doesn't say that Mr. Cadi is not a terrorist, or that his assets have undeservedly been frozen. What the court says is that his assets, he has not been given the opportunity to know why he is perceived as being associated with terrorism, and asks the EU to provide a statement of reasons. The EU provides a statement of reasons, but given that the statement comes from the United Nations, the information is intelligence information, he gets half a page of reasons. So he goes back to the court and says, well, that's not good enough. These are not reasons. You're not explaining to me what is the basis of the decision. So there is a second round of litigation, and it becomes more difficult. The question really for us as lawyers is this: what is the standard of scrutiny? What is it? How far should the court go in unpicking the decision-making process? Should the court review the evidence? So would it act really as a fact-finding court, or would it be sufficient for the EU to provide some kind of general general statement of reasons? What about intelligence information? Can the EU say, well, we know the evidence, but we can't let you know it because that is intelligence information and we cannot reveal its sources? So you can see here many delicate questions. In effect, in a nutshell, what happens second time around is the EU loses again. The court says first it says that it will follow a high standard of scrutiny. It's not a matter of supplying a general statement of reasons, but it must, the court will verify the evidence, will go through the facts to establish that the evidence presented is coherent and justifies the listing of a person. And then there is a whole lot of case law determining what the EU can do and what it cannot do. After CADI, you have all sorts of cases coming to the court, some of them in relation to sanctions against terrorists, others in relation to sanctions against Syria and against the Ukraine, against Russia because of the invasion of the Ukraine. And you can see here the juxtaposing interests. How, on the one hand, the EU has to provide reasons. On the other hand, it's an open question, to what extent can the EU use presumptions? Can you impose economic sanctions against family members of the Syrian president? Can you say, well, if you are the wife of President Sadat, then, well, you are associated with the regime, and therefore your assets should be frozen? How far can you? What if you're a cousin? What if you are the managing director of a state company in Syria? Is it fair for the EU to presume that you can only have this position by being favorable to the regime, and therefore you are a legitimate target for these sanctions? So you can see that there is a lot of scope here for legal argument. Indeed, there's a long line of cases on sanctions, and the rate of success against the European Union tends to be quite high, unusually high in those cases. And I made all this introduction really not to talk about sanctions as much, but to talk about the Rosneft case decided, as I said, in March. And what is the issue here? The issue really is this, that the EU imposes economic sanctions on certain Russian companies because of the invasion of Crimea. And one of the sanctions are quite far-reaching, and they also prohibit contracting with certain parties. Companies may not contract with corporations which are associated with those responsible for the invasion of Crimea. And what you have is a company that seeks to challenge those sanctions by way of preliminary ruling. This is the first time that it happens. Usually, if a sanction is addressed to Mr. Kadi, then Mr. Kadi goes to the court in Luxembourg, to the General Court, and on appeal to the European Court of Justice by way of direct action. But for the first time in Rosneft, what we have is a corporation challenging a CFSP measure via a preliminary reference. So let's look again at Article 275. What does it say? It says the Court of Justice shall not have jurisdiction with respect to the provisions relating to CFSP, except in two cases: to monitor compliance with Article 40 and proceedings brought in accordance with the conditions laid down in the fourth paragraph of Article 263 of this treaty, reviewing the legality of decisions providing for restrictive measures against natural or legal persons. So what Article 275 paragraph 2 does is to create an exception for direct actions, for a Kadi kind of case. A person on whom sanctions have been imposed can go to the court and ask the court to lift the sanctions against that person. But in Rosneft, the case comes to the court not via direct action, but via the reference for a preliminary ruling. Nonetheless, the court accepts jurisdiction. Okay? The court accepts jurisdiction, and it is, I think, an important ruling in the field of judicial protection. Why does the court accept jurisdiction, even though Article 275, paragraph 2 states that? Well, if you look at the reasoning, you will find there all the components of the court's traditional teleological approach. The court says, well, the idea is that the preliminary reference and direct actions are complementary procedures. They both seek to ensure that there is effective protection of rights. They seek to ensure that there is a complete system of remedies, and there is nothing to suggest, the court says, that Article 263 is the only way of seeking judicial protection. The reference in Article 275, paragraph 2 to Article 263 is, the court says, is not to determine the procedure, but to determine the kind of measure that can be challenged. So when Article 275, paragraph 2 refers to proceedings brought in accordance with the conditions of Article 263, reviewing the legality of decisions, that really does not mean only under Article 263. It does not intend to refer to the procedure, but it intends to refer to the type of decision that can be challenged. I don't think anything could be further from the truth if you look at Article 275, paragraph 2, clearly talks about proceedings brought in accordance with the conditions laid down in the fourth paragraph of Article 263. I think Rosneft gives a contra legem interpretation of Article 275. I'm not saying it is the wrong interpretation, but I think that it's very difficult to disguise it in any persuasive terms. What the court is saying is there is a fundamental right to judicial protection. There must be access to all remedies provided by the treaties, and that takes priority over the language of Article 275. It is a classic case of procuring an interpretation of a provision of the Constitution which conforms with a higher provision of the Constitution. What the court is saying is there is, at the apex of the EU constitutional system, there is a right to judicial protection. It's protected by the Charter. It is protected as general principle of EU law, and you cannot let Article 275 take precedence over it. Whether you agree or disagree with the judgment is a different matter. So the court opens the way for challenging CFSP decisions that impose economic sanctions by means of a preliminary reference procedure, then goes on to look at the imposition of sanctions and dismisses the challenge. So the substance is, in substance, it finds in favor of the EU, but it opens at least the door for the possibility of challenging CFSP measures. Yes.
When they made that decision, did they look at the evidence or not?
Yes. In other words, how far the court went down in the... That's a good point. It's because they did, but because it was a measure that effectively prohibited contracting with certain corporations, there wasn't really much evidence to look at. There wasn't. That's why I said earlier, the court says we are going to look at the facts. Okay, you cannot impose economic sanctions unless you look at unless you prove that a person is associated with terrorism. So how does the EU get away from that? It gets away with it by the use of presumptions. If I say that I impose economic sanctions on someone because that person has taken part in terrorism, then I have to prove that that person has taken part in terrorism. If I impose economic sanctions on a corporation because I say this is a state corporation and we are taking measures against any state corporation of the Russian Republic, then there isn't really very much to prove. It's not a factual evidence. Then what you test is the scope of the sanctions.
Having first decided decided it was indeed a Russian corporation?
Correct. Yes. You would still need to go through the factual evidence there. You're absolutely right. And in some cases, I think in the Crimean case, that was never a problem. It was in a couple of cases. In some cases, it is a problem, and especially in Iranian sanctions. The reason is that many Iranian vessels, merchant ships, are controlled by Iranian interests, but they don't necessarily fly the flag of Iran, and they get reflagged through their ownership changes through nominee companies, sometimes on a weekly basis. So it's impossible to know if a ship is owned by the Iranian state or not. I mean, these economic sanctions, there are two elements to it. Yeah, it's a very interesting question you raised. There are two elements to it. One is the personal element, which involves human rights. Okay, once assets are frozen, there is a case, was a case in the United Kingdom. It may sound ridiculous. The truth is, it makes perfect sense, because if you have a sanction, you have to enforce it. And the case is as follows: the husband is in the list of persons on whom economic sanctions are imposed. No criminal element. Economic sanctions are imposed. The wife is on a social security benefit. Okay. There is a clear obligation not to pass the social security benefit to the husband. That would be a criminal offense. And the husband goes to the cinema with the son, and the treasury says, well, what's happening here is the wife's social security benefit is financing the husband's ticket, which is for recreational purposes. It's not by any means a necessary expense. So the social security benefit has been diverted to pay for someone who is in the list, and stops the social security benefit. So it's a very human aspect. You may agree, disagree, I'm not looking to this, but this is a human rights element of the sanction. Another aspect of them is that they are very disruptive to commercial relations, because even though the sanction is imposed on a specific person, these sanctions are in fact of general application. All the sanctions regulations, Article 2 or 3 typically of the sanctions regulation, will provide as follows: no funds may be made available directly or indirectly to a person who is in the list. So this is an obligation on all of us. Nobody can pass money to a sanctioned person. And how can that be disruptive? One of the ways it can be disruptive, for example, is because of insurance payments. So if you have Lloyd's provides letters of insurance, and these are crucial for marine insurance, for example, all sorts of other insurance, because it is a promise by Lloyd's to pay without any questions being asked. Okay, so if I have a ship and the ship gets involved in a collision somewhere in China, okay, we don't know if it was the fault of my ship or the fault of the other ship. I provide a letter of undertaking from Lloyd's, and Lloyd's promises to pay in the event that it is my fault. Okay, that is very important. Why it is important? Because what I want to make sure is that my ship is not arrested in China and therefore gets out of service, and I'm unable to comply with undertaken contractual obligations for the future. In other words, the priority is to get the ship back. Now, if the sanctions regulation says that no funds may be made available directly or indirectly to a person listed, the question is there a duty on the insurer to make sure that the letter of undertaking does not go to someone who might be controlled directly or indirectly by a a person in the list. In other words, is there an obligation on Lloyd's to say, well, wait a minute, I want to make sure that the owner of the other ship with which you collided is a good guy and is not controlled indirectly by the state of Iran or by a state or by Syria or by another state on whom sanctions are imposed. If you impose such a duty on the insurer, then the letter of undertaking becomes much less valuable, okay? Because the immediate reaction of the ship owner would be not to go to Lloyd's, to go to another company outside the EU, which is not bound by the sanctions, to get the commercial certainty that you can no longer get because of the sanctions. So this is just an example, but it gives you two separate aspects of the sanction system and how it works. A policy that the EU has followed for a while, and it really, in my view, highly undesirable and illegal, is the EU would put people in the list. Now you think about this as lawyers. The EU puts someone in the list as being associated with terrorism or as being part of the sanctions. Then that person has his assets frozen, brings an action before the European Court. That takes a while to be adjudicated, okay? And shortly before the hearing, the Commission says, oh, okay, we'll take your name out. There's no point in deciding on the proceedings for judicial review. It's a very, the question is, in law, would there still be a point in having a judgment? What do you think?
Claiming damages.
Claiming damages. Why damages and not the judicial review?
Well, somebody's ability to trade.
Yes.
We'll see that all sorts of opportunities.
Yes. It's an interesting point. Of course, the initial action may well not be for damages. The initial action may just be to have one's name removed from the list. And one way of going about it to say, look, if someone's name has been removed, then the action has lost its object. There is nothing to do. That person is no longer subject to sanctions to the extent that there is a claim in damages. That should be the subject of another set of proceedings. If so, you let the EU get away with behavior which may well be illegal, and you may well also have a kind of adverse reputational element. It's not particularly good news to have your name in one of these lists, and then no means of redress. So, if you look at the case law, it's extremely interesting. It also gives you an indication of the limits of judicial power, because Mr. Caddy has won his cases. The truth is, his name has not come out of the list. I'm not suggesting the court has done anything wrong. There's a limit what the court can do because of the limitations inherent to judicial power. I'm aware of time. Okay, let me say one word, if I may, about opinion 215. This is the Singapore opinion, okay? And what the Court of Justice effectively says here is that the trade agreement between that the EU and Singapore are envisaging of concluding has to be concluded in the form of a mixed agreement. The court, I will outline just 2 points, 3 points, if I may. First of all, the court draws a distinction between foreign direct investment and non-direct investment. So what is foreign direct investment? Well, the court says if you acquire shares with a view to having a say in the management of an undertaking, then there is a commitment to make a direct investment in that corporation. And that is a matter of the common commercial policy. So the acquisition of a controlling shareholding by American company in an EU company would be governed by EU law. The conditions, if it is permitted, if it is not permitted, and so on and so forth. If it is portfolio investment, you invest in an EU company not with a view to run it, but to make some money because you think it's a good investment, to have money in Volkswagen or to have money in a British corporation. That's not a direct investment. It is for each country to decide whether to allow that for its corporations. But the distinction really is sometimes very difficult to sustain. So the court provides some explanation of what is a direct investment. Secondly, what the court says is that sustainable development is part of the CCP. That's an important, that it broadens, in other words, the common commercial policy. And it says sustainable development and protection of the environment also have a CCP element. But the most perhaps important aspect, I think, of the case is this. The court says that whether the EU has competence or the member states have competence also depends on the dispute resolution procedure provided in the international agreement. These international agreements would typically have two kinds of dispute resolution mechanisms. One is a government to government. In other words, the EU can sue Singapore because Singapore fails to comply with the agreement before an arbitration tribunal, or Singapore will sue the EU. And the court says this government to government or state authority to state authority dispute resolution system falls within the exclusive competence of the European Union. But if there is an investor state dispute resolution system, in other words, if you allow investors from Singapore to sue the United Kingdom or the EU, usually they would not sue the EU, they would sue the government of the country where the investment has taken place. If you allow investors from one contracting party to sue the other contracting party in an international tribunal, then that is a matter for the competence of the member states, because an investor state dispute resolution system removes jurisdiction from the national courts. To the extent that you permit a Singaporean company to sue the United Kingdom, not in the courts of the United Kingdom, but in an international arbitration, then that removes a certain category of disputes from the domestic jurisdictions. And the court says this is really for the member states to decide. It cannot be decided by the EU by itself. So even if the substance of the commitment falls within the exclusive competence of the EU, insofar as there is investor-state arbitration, the agreement ceases to be a matter of exclusive EU competence, and it becomes also a matter of national competence. So the court effectively decouples substantive obligations from the dispute resolution system. Insofar as an international agreement provides for investor-state arbitration, the member states have to be involved, which in turn effectively means the likelihood, if such a dispute resolution system is included in whatever agreement governs the future relationship between the UK and the European Union, it means that that agreement will need to be a mixed agreement, will need to be ratified by all the member states of the EU independently. It would, in other words, need, as things stand at the moment, need to be ratified by no fewer than 36 parliaments, making the process of ratification highly laborious and increasing the possibilities of an accident, as it were. So it's an interesting case because although the court in the Singapore case appears to increase EU competence, at the same time it does not necessarily make it easier for international agreements in the field of trade to be concluded. I will provide the PowerPoints. Thank you very much for listening. I'm sorry that was very concentrated, very dense. Thank you.